Good morning. We are live from the chamber. Before we begin, I'll go over the emergency response plan for this room. In an emergency, everyone must evacuate through the nearest safe exit. Those seated in the gallery take direction from security to evacuate, and council takes direction from myself. After evacuating the room, please proceed to a stairwell, take the stairs to ground level, and evacuate the building through the doors marked emergency exit, and go to the muster point. Do not take an elevator or walk through the city room. Anyone with limited mobility should identify themselves to security or myself during an evacuation. And finally, please speak with security or myself if you require first aid. Thank you.
All right, good morning, everyone, and welcome to today's Code of Conduct Subcommittee meeting on November 1st. At this time, I'd like to acknowledge that we meet on the traditional land of Treaty 6 territory and the Métis homeland, and acknowledge the diverse Indigenous peoples whose ancestors' footsteps have marked this territory for centuries, such as Cree, Dene, Saulteaux, Blackfoot, Nakota Sioux, as well as Métis and Inuit, and now settlers from around the world. So I'll start out with a roll call of committee members. Councillor Rutherford.
Good morning.
Good morning. Councillor Knack.
Good morning.
Good morning. And I'm aware that Councillor Rice is going to be away with notice today, but we're also joined by Councillor Wright in Chambers.
Good morning.
Good morning. I see Councillor Paquette online.
Good morning.
Good morning. Councillor Principe.
Good morning.
Good morning. And Councillor Cartmel.
Morning.
Good morning.
Good morning.
Excellent. So adoption of the agenda. Can I get a motion for that, please?
I'll move adoption of the agenda. I don't believe there are any changes.
Nope, no changes. Okay, let's vote on adoption of the agenda. I'm a yes.
Thank you, Councillor Salvador. We have all the votes.
Please display the vote. That is carried. Any protocol items? None that I'm aware of. So we can move to selection of items for debate. And I'll look to the board for those. Councillor Rutherford?
Yeah, I will select 3.1. I have a potential motion on that one. I do have questions on 3.2, so I can also just select that one as well if there's no one else on the board.
That sounds great. So 3.1 and 3.2 selected by Councillor Rutherford, which is all we have on the agenda today. So vote on reports not selected for debate. And so request to speak, we have none. Time specific on the agenda, none, which means we are getting into our first item. And I just want to clarify with the clerk, I know on the agenda it does say that items 3.1 and 2 will be dealt with together. Is it possible to separate those? I know just given some discussions, it might provide some more clarity if we're able to separate them.
Absolutely, at the behest of this committee, they can deal with these items as they see fit.
And I'll just look to my committee colleagues, and I'll look online as well to Councillor Rutherford. I see a nodding head. Is that okay with everyone? Excellent. Okay, so we'll move to item 3.1, turn it over to administration.
Good morning. With us today, we have our ethics advisor, our integrity commissioner, as well as guests from legal services this morning to help answer questions this morning. And a great segue, Councillor Hamilton, we wanted to mention that we have both items 3.1 and 3.2 on your agenda because together they represent the amendments to the substantive part of your code as well as the procedural amendments. But given we have a lot of material before you as part of these amendments, our suggestion this morning is to work through the amendments in the order they would appear in the code, which has us starting with attachment 2 of item 3.2. And that would be the recommended changes to Schedule A, which is your substantive rules. And then once we get through the discussion of Schedule A, we will move back to item 3.1. Again, suggest using attachment 2, that is the track changes version for simplicity, and work through those schedules B and C for the procedural aspects. Any directions for changes? We can ask questions as we go, of course. And any direction for changes we can capture in a list and collect those as motions to be passed to give us direction on what needs to be changed. And once we have that list and idea of what type of changes are be looking forward, myself and the clerk will give you some advice on the best way that those changes can be advanced and brought forward.
That sounds excellent.
So unless our Integrity Commissioner Ethics Advisor would like to say a couple words to start, I think we can move straight into questions.
Oh, and you'll just need to turn your mic on.
I just welcome the opportunity to provide input with respect to these important matters.
Me too. Yep, thanks.
Okay. Alrighty, so if we're open to just jumping into questions, I know Councillor Rutherford, you had selected this. Would you like to start us off?
Sure, I'm just unclear. Are we starting on 3.2 or
So
3.1?
we're going to start on 3.2.
Okay,
Just given the flow of the actual bylaw itself, and then we'll loop back up to 3.1. So we're doing the sections in order, essentially.
okay, so I can ask any questions on the red line version of 3.2.
Yes.
Okay. One of the questions I had related to communications. One of the things that Part B is silent on that I thought maybe needed some strengthening is potentially something about their voting records. So we talk about the facts representing council's decision as a whole, but I was wondering about if it's by default includes their voting record, or if we need to be more explicit with that, or any thoughts on that from the Integrity Commissioner.
Councillor Rutherford, are you referring to people being able to speak about how they vote? Like
Yeah,
access
it
to
says
that?
in Part B, communication, ensure that they accurately reflects the facts of council decisions, and that it talks about not to mislead council or the public on any matter relating to the decision of council or the business of the city. So I was wondering if by default, the decisions of council include their own voting record, or if that needs to be a bit more explicit.
Yeah, I think it's fine. I think the issue comes up is what can councillors say or not say about how they voted, and you're entitled to talk about that, but you still have to you have to uphold the decisions of council, right? The majority. So you may be asked, why did you vote this way or that, and that's okay to answer that. And then the voting record, I'm not sure I'm following your question.
So for example, a councillor votes no on an item in the decision of council, but then puts out a post saying that they support that thing. Is there an issue there in terms of potential misleading of the public on their actions and their position?
That would have to be looked at contextually and on a case specific, on an
But it's
individual
covered,
basis.
but I'm just
yeah.
getting, that's an example, but that would be covered as it's written right now.
Well, if you're misleading the public about, the work of council, I see what you're saying. It's not saying misleading the public about what you've done. The code as it currently is proposed just says misleading the public about council or the city, but not what you personally have said or done when you're voted. Is that the distinction you're
Yes.
talking about? Yeah.
Yes, that's exactly what I'm talking about. So I'm just trying to get a sense of whether that needs, so it's, my timer's not going, so I have no idea what my time situation is like. But I think that's one that I just had a question about whether that should be strengthened or not.
So I guess, the way you posed it, so if you look at 1C, it's sure that all communications are accurate, et cetera. So if it's inaccurate, it would depend, because sometimes people vote no, but then the decision's made and they're accepting. So that's why I say it can be so contextual. And if people bring something to me, I can't just say, oh, you voted no, and then you said I support it. Wouldn't jump to that conclusion necessarily. So I think that these general principles would be fine in that scenario, Councillor Rutherford.
Perfect. And then I'm just going down looking at my notes again. Okay, I have a minute and 40. Okay, and then I did have a question about, and this might be to the ethics advisor, talks about in section Part K, section clause number 5, it talks about website and electronic mail distribution lists that are used for official duties may not be used for campaign activities and communication. And I found that one a bit confusing in terms of right now, if a counselor technically is using their website for their official duties, but my understanding was it wasn't any city resources. So for example, I'll use myself as an example. I don't pay for, I pay personally for my website. Can I just get clarity on that one? Because that to me is contradictory to what I understood.
If I understand your question correctly, and I think I do, and Jamie might want to supplement, I mean, if you are exclusively using social media resources that you control and that you pay for, then you're not using any city social media or electronic mail. But I find it difficult to believe that you don't have a city email account. But
No.
I don't know.
I'm talking about the way that it's written. It says website used for official duties. One could argue that I use my website right now to put out blogs and information. I'll come back for second round. Thank you.
I think the spirit of, and I do appreciate that perhaps it needs some clarification, but I think the spirit is that you'll have, if you have a city paid for and website that you post items to, blogs and events, that you'll maintain a separate website for electoral processes. But I see what you're saying, that that's not as clear as it could be. But I think that's the spirit of it.
Thank you, Councillor Rutherford. I might loop back to some of those questions as well, but I actually wanted to start with some questions on, let's see here, Part G, I believe it is, conflicts of interest. Yeah, I just wanted clarity. I know we added language around and other conflicts of interest beyond pecuniary. Can you just help me and remind me what was the intention there? What are we working to cover? And then as a secondary question, I'm wondering how this might change given some of the new legislation.
I can help you with that, Councillor Salvador. So this actually was not in the version that you looked at as part of code, because we weren't aware of the changes that were coming for Bill 20 the last time that we looked at this. So this is to address, and one moment.
To those joining online, we're just experiencing a few technical difficulties. Just give us a moment.
We're back.
We're back. Excellent. Sorry, please continue.
Apologies, we just technical issues there. So we added this to address the change in Bill 20 that allows for conflicts based on private interests. So that language was added just essentially as a housekeeping to reflect the reality of what your legislation now says as of yesterday.
Can you help me understand what exactly that means and how broad
For sure.
that is?
Go ahead, Brent.
Well, this has come up a number of times in a number of contexts, and there's not always been universal agreement at this table. But I believe that there are identifiable conflicts of interest that go beyond the narrow definition of a pecuniary interest in the code. And I think the amendments to the provincial legislation reflect that, and therefore need to be reflected in your code of conduct. That there are going to be you're going to find yourself in conflicts of interest that may not even be financial. There might be a matter where somebody is, for whatever reason, the subject matter of a motion or a bylaw. I mean, most of them will be financial, but most conflicts will be, but not necessarily pecuniary, because the definition of pecuniary in the MGA is very narrow to the counselor's family, but not close personal friends, not next door neighbors, people that you might be very close to, and I think should not be participating in especially procurement matters or subdivision matters if you have some sort of personal relationship with the individual that is outside of the narrow family definition that would make it a pecuniary interest.
I might seek some clarity from Nancy Jacobson. The legislation is pretty specific, so I think the interpretation of the legislation is much different, different than that, so maybe Nancy can clarify.
Yeah, so council, what they have done is before you had the pecuniary interest, and as Brent noted, it is limited to sort of yourselves and your direct family. They've added another category. They haven't expanded the scope of the who, but they've added another category of you can declare a conflict of interest or perceived conflict of interest in relation to a private interest. And a private interest doesn't have a all-encompassing definition. It simply says what it is not. So it is not a general matter. It is not a matter that affects you as a broad class. It is not a matter relating your compensation or benefits, and it is not a trivial matter. Anything else can be a private interest, and that is an option for you now to disclose. So we needed to adapt your code to be able to say that you have that option to do so.
Okay, well, I appreciate that. So essentially, these changes that were not in there initially are a reaction to the changes being brought in. We're confident that it's in alignment with. Yes. Okay, excellent. Okay, I also wanted to ask about, hang on here, also in relation to Bill 20, I guess there's language in the code a number of times that references partisan political events. I'm wondering how that changes, or if that changes, or the interpretation changes based on what is happening with Bill 20. Or if we've looked at that yet.
So Bill 20 will definitely bring in local political parties, as we know. As you've heard, there are restrictions of what the parties can do in the first couple of years and things like that. I think if I can imagine what Jamie is going to say, it's going to be very contextual and to decide. These are meant to speak about partisan events where it's particularly party related. It may be a little bit of we have to let that play itself out and see what it looks like and issue further interpretations. But Jamie, I don't know if you want to add to it, because this unfortunately is very new to us as well.
Yeah. Your inclination earlier on that we haven't looked at this yet is true. So yeah, I think we do need to consider that more deeply, because that will be coming, those questions will be coming into my office. Yeah, so,
yeah, okay.
Yeah, a good point, and I'm glad you've raised it, because we will look at it.
Yeah, because I could see that being interpreted in a number of different ways by the public, whether it's, yeah, I'll come back, but I'm out of time. Go to Councillor Knack.
Thank you, Councillor Salvador. Thanks for all of this. I want to circle back to the last question Councillor Rutherford was asking about Part K, Sections 5 and 6, because, and again, maybe we need to clean up the language, because last year, or last term, the way it worked was that so I'll use myself as the example, because I followed and we had these conversations, and this is exactly how we went through into 2021, which is that I have a website which I pay for myself. I use to insert, I put up blogs and all of that content. Once we hit May 31st, what I did is I continued to pay for my website individually, as I always did, but I removed every reference to me being a city councillor. I removed any reference to a city email or a city phone number that would essentially tie me back to being a councillor, and I ran it as an elections website with no reference to me as a city councillor, no city email, no city phone number, but it was the same website. And I did the same with social media, where in the past I identify myself as someone that serves as a councillor. When we hit election time, that May 31st, I removed all reference to that, any link to any city website, anything that could connect it back to a city site. So that's how I know, and I wasn't the only one that did it that way. I know a number of councillors did it that way, and individuals that ran. So do we need to update the language to reflect that? You know, essentially, that's what we were told we could do, and that's how a number of us behaved. Does the language in this create confusion then?
Well, first of all, I congratulate you on the steps that you took to separate your re-election communication from your official duties as a city councillor. I think what you did was very prudent, and is a good best practice for all of us to consider. So when I read the current reading of Part K, Paragraph 5, it refers to the city's website, singular. So when I read that, without any context other than the exact words, I think that refers to the official city website. So if you are using stuff on that website, even things like you have contact information on there, presumably your phone number, your email address. Once the election gets called, I think that requires a divorce between the city website and the election website. And I think how you handled it, Councillor, was right on the money.
Okay, and so I think it sounds good. I want to dig into that one more piece, because there's a Edmonton.ca website that has a page for every city councillor with our contact information. We don't manage that. That's not our website. That's the City of Edmonton's website. Using myself as the example again, I have always had the same website. It's just my name, andrewnack.com or andrewnack.ca. And again, up until May 31st, so once I got elected, so starting in 2017, I continued to use that website as a city councillor. I named myself as a councillor on the page, linked all of that. Again, I paid for that site. The city didn't pay for that site. But then May 31st came, and that website domain continued, but nothing that again, removed all reference point. Any people that signed up for my email list, I didn't carry over to a campaign email list. So when you use the word city website, I'm just trying to confirm, are you talking about the Edmonton.ca website, or in the example that I gave, is that in compliance of the rules as your understanding?
I mean, I was referring to the Edmonton.ca
Okay.
website.
Okay, great. Okay.
And I mean, and you don't control that website. So
No.
if the city maintains links to your phone, I mean, you're still a city councillor until next October. So, and you may be out door knocking, but your staff should be taking those calls.
That's right.
And answering those emails. So that's all legitimate. If it's
You would want to, the one thing we'd want to make sure is that the city website, and I don't think it does, wouldn't have a link to our personal website.
Correct.
And I haven't gone to it in a while. I don't think it does, so I think we're already covered there. But if it did, that would be a concern, because then you would be linking to what is essentially a campaign website from an Edmonton.ca.
Yeah, I think that would be more than a concern, Councillor. I think that
Well, it'd be a violation. Yeah,
But-
exactly.
But you don't have to, lobby the city to take your name and your office phone number and even your email, office email, down just because there's an election on. Because, like I say, your staff should be taking those calls and answering those emails.
Perfect. I'm out of time. Thank you.
Thank you, Councillor Knack. Councillor Wright.
Thank you. I'm just wondering, Part H, the use of influence, and I'm not sure if I missed this at the last subcommittee meetings, but why is number 1 being removed? Or is it being replaced anywhere?
It didn't really fit in this section anymore, and we had conversations about could it be in another place? And so just as an overall review, we looked at it. It didn't need to, it was dealt with elsewhere, and we also added the new Part N that sort of covered it, so it just didn't fit anymore.
Okay, all right, thank you. And then getting back to the conflict of interest, so I understand, like, our, when we're looking at immediate family members, it's only spouse, parents, children, correct? Mr. Rothberger, when we had an item came forward to our Community and Public Services Committee on pesticides, I had a nephew that worked with a company that provided lawn care, and I was concerned that I had a conflict of interest there. Now that there's a broader definition of some kind for conflict of interest, would I have to take that in account if it was, you know, went to the livelihood of him and his family?
Well, clearly under the existing code of conduct, that's not a pecuniary
Right, yeah.
breach. I think potential conflicts outside of the now former narrow definition need to be examined on an individual basis. And to some extent, and maybe the Integrity Commissioner might want to supplement my answer, but I think to some, and from my experience at other levels of government, some of this stuff is self-policing. So you got to ask yourself and look in the mirror, you know, can I objectively participate in this debate knowing that so-and-so is somehow related to somebody that I'm related to? And the answer to that question is probably more often than not going to be, no, I'm not in a conflict. But if you think you cannot, in good judgment and in good faith, be unbiased and objective in whatever matter you're deliberating because of a potential conflict, well, I think you should get counsel. And if you're not feeling good, if your spidey sense is telling you that you shouldn't participate and vote, you probably shouldn't participate and vote. But it's not cut and dry. I think you've identified that in your hypothetical. It's very gray.
Okay. And so I guess maybe what sort of proof or evidence would somebody have to come forward if I felt that I could make my decision independently of anything else? What sort of, I guess, proof or evidence would somebody need to bring forward?
That's
say that I wasn't
That's an investigative issue. I'll let Jamie respond to that. But just let me say one further thing: that if you're in doubt or if you're questioning whether or not you're in a conflict, you should probably err on the side of caution and step back.
And if I may, so with Bill 20, the way it's written, that whether you decide to recuse yourself or not or declare a conflict, it's now taken out of the realm of codes of conduct, right? So, and Michelle and Nancy can correct me if I'm wrong, but I believe it's now, I couldn't investigate you anyways.
Okay.
Yeah, and I think, Nancy, can you just provide your the expertise on Bill 20? There's a very specific section on that.
Yeah, in terms of the investigation piece, the private interest piece, and whether a councillor just chooses to exercise it or not is not something that is reviewable under the code.
And that's as of yesterday. And so because the Municipal Government Act still says that codes of conduct have to have a section called conflict of interest, in recent feedback given to the Government of Alberta, we've asked for clarity on how to deal with this now, because what does that mean now? And so there is confusion around this, but certainly it's not something that, as of yesterday, I can be investigating about whether you decide to vote or something or not in a council meeting or committee meeting, right? So I think there's going to be more to come, because I think there's going to be some changes coming to the Municipal Government Act within the next 6 months or so. And I've specifically asked for more clarity on that.
Oh, okay. And hoping those changes will provide that clarity?
Hoping, yep,
Okay.
yep.
Okay, thank you. That's all I have.
Thank you. Councillor Rutherford.
Yeah, thank you. Just circling back to close the loop on Part K, Section 5 specifically is what I'm talking about. It's the first part's clear. The councillors may not use a city website, blah, blah, blah. It's the second part that says website and electronic mail distribution lists that are used for official duties may not be used for campaign activities. That is what is tripping me up, because the only reason I haven't maintained a website right now, even though I would pay for it personally, is for official duties to provide communication to the residents that I serve, as an example. So I'm wondering if a slight amendment to Part 5 that says city funded before website and electronic mail distribution lists might be the clarity that would just add a little bit. Any thoughts on that from their ethics advisor?
If I may say, Councillor Rutherford, what the concern is here, and there is a reported case or investigation that I've done on this, and the concern is that people gather electronic email lists in their official duties, and then they use them for their campaign. That's what this is addressing. And so I get that you're worried about the lack of clarity between the work that you're doing as a counselor and then when you're running for office again. And so I appreciate Councillor Knack's advice on this, because we usually have a session before the election getting you ready for this, but we do ask you to keep those things separate. So if you've gathered a list of, if people have sent you emails because you're a counselor asking you questions, you can't take that list and use it for a campaign. You have to develop your campaign list separately, and we suggest you have a separate site for your campaign.
But that's why city funded might add that clarity, because I'll give another example. I have a sign up for my e-newsletter on my website. Obviously, getting people are signing up for my newsletter because they're wanting information that I'm putting out as an official counselor. It's that official duties. So am I then not allowed to use that newsletter sign up that's on my own website that I'm hosting for a campaign? Like, is that how, in the way it's interpreted right now?
I think the short answer to your question is you are not allowed to harvest that data for campaign purposes. What other councillors and other politicians have done is they've asked the individuals if they, if they would object or would allow their information to be turned over to a campaign. That's not the exact wording, but there's a way to do it so that the person is invited to sign up to a political newsletter, as opposed to you simply harvesting their email address off of a official government counselor communication tool like a website.
Okay.
Can I just say quickly, when this came up before, it created a lot of reaction in the public when that was done, and so the better way is just, if you collect that information from one reason, then use it for your official. You can say, may I have, there's a way to actually get that list developed, but it has to be separate, right?
Okay.
And we can provide a session on this in advance of the election campaign. Yep.
And then my last question is around Part C, decision-making process, Clause 3. I'm just wondering what that is envisioned to look like, because I'm not sure that's necessarily happening now. And I don't know what it's adding to the decision process. So can you speak to this Part 3? Again, I know there was no changes made from before, but I'm just wondering if, since we're making changes, what that adds to the code of conduct.
You're talking about Part C, Section 3, Councillor Rutherford?
Yes.
Councillors will not provide information contained in records or documents at a meeting unless those have been provided to all of council in advance, if possible. I think the city clerk or Nancy can speak to this, but that's just the normal process of making sure that people are given the information in advance. Is that correct?
Yeah, so from the historical experience of working through this, the first time this was passed, there was some feelings at council time that it would be a courtesy to members of council if information that you intended to advance that would support questions or the discussion was shared rather than being brought live in the meeting, so that more councillors had an opportunity to consider it, was the context for this one.
Okay. I don't think that's necessarily happening, and I'm not sure that anybody would file a code of conduct complaint against that. So I don't know if that has teeth, but I'm out of time again.
Thank you. Councillor Wright?
Thank you. I'm just going to ask one more question about the website stuff, or the data collection. As a counselor, would it be appropriate, and maybe this will be covered off before, when you give us our advice before the election, would it be appropriate to sort of create that delineation between the two by sending an email to all those on your email list, letting them know that you're shutting down the counselor site and asking them to sign up again, or asking for their permission to use their data as an elected or as a candidate?
Yeah, but you have to be very careful with the wording, because you don't want to be seen to be using the city website as the conduit for you to harvest.
Not the city website, our own individual
Yeah.
site.
So if you put in, if you put an individual or an invitation for them to sign up for a non-city political website or re-election website, I think that's okay.
I think we just need to give you some real better guidance on this, and we will. I think Councillor Knack nailed it. He's sort of in a bulletproof kind of way, so good for you, Councillor Knack. But I'm going to go back and look at what went wrong before and take those lessons, and we'll get something out to you sooner rather than later so that you have time to prepare for this.
Okay,
right?
perfect.
So, yeah.
Looking forward to it. Thank you.
Because there's nuances there, and I also don't want to be directive on it because every councillor wants to run their campaigns and do what they want to do as they do it, right? So we want to leave that discretion, but give some preventative advice for sure. So we will circle back.
Any cautions you can provide is appreciated. Thank
Yeah,
you.
we absolutely would love to provide that preventative information.
Thank you, Councillor Wright. Okay, so I'm not seeing anyone else on the board. Maybe I'll just to Councillor Rutherford's earlier point around Part C, what is it, number 3? I mean, I tend to agree that I don't know if that's necessary to, I don't know if it needs to be included, quite frankly. Is there anything else that can be shared as to just like the efficacy of having something in there, why that's necessary?
It wasn't a mandatory part of the code of conduct. It was a request at the council at the time that prepared this for that to be included. It is simple if you would like to just move that it be deleted. I'm not seeing an objection from this table.
Okay. I'm just looking around the table to see, you know what,
Can I say something? I'm just curious I agree, I don't think it's come up in the 6 years that I've been involved with this code of conduct, but I don't know what the harm is in leaving it in.
Yeah, I guess for example, you know, councillors will not provide information contained in records or documents. Like if there's something topical or relevant that comes up live in a meeting, this would say that should not be shared during that meeting, correct? That it should have been shared in advance?
Yeah, I mean, the purpose of the rule, as you've identified, is that you can't, ambush your fellow councillors with information that they didn't have privy to. Now, there may be situations where information, for whatever reason, didn't become available until yesterday, the day before the meeting, and I guess the chair will have to deal with that. But are there not procedural rules regarding how many days in advance documents need to be filed with the clerk? No? So, I mean, we're all lawyers, so we know that there are deadlines with respect to filings, and I guess that doesn't apply in your procedural world. Mm-hmm. So I think you might want to keep a provision in here to prevent a blatant attempt to have somebody caught off guard by a document that they could have been provided with, but for whatever reason weren't. If you're sitting on something and then just referring to it at a council meeting. Mm. I don't think that kind of ambush should be allowed.
And if I may respectfully add a different perspective, and that is, I've not taken the view that I'm that I police how council meetings are run unless somebody comes in and acts in a way that's truly lacking in decorum. Mm-hmm. And so that's something for the chair to deal with, for council to deal with usually. I've seen this come up in other jurisdictions, and it's usually for council to deal with, and I'm so it's interesting our different roles, because I'm picturing getting a complaint about this and thinking, is this something that I would want to be investigating, that somebody brought information to a council meeting? I don't usually get into those procedural things. I usually say, bring it up with the chair, bring it up with your council, and also the clerk will have, requests for materials in advance, that kind of thing. So I see it more as how you operate and less more of an integrity issue.
Madam Chair, I think just from my perspective, being in council meetings, I think reference to records or documents happens all the time. And sometimes it's not great, and other times, you're relying on so many different things coming at you as a councillor or the mayor. So I don't necessarily want to draft your code, but it may be worthwhile narrowing this, because you talk about every document, every record. Well, you all have access sometimes to different material. But I think if an issue comes up and a counselor is relying very heavily on something, then I think it's fair that everyone should have access to it. But I just find it's a bit overbroad. I think of a circumstance where, Counselor Jans often refers to media pieces or different things. So anyway, I just think perhaps an idea would be to narrow the scope or at least fine tune it so that it's clear. Because right now it's completely prohibitive to do this at all. And I just find when you talk about records or documents, it just seems overly broad to me.
Yeah, and just not reflective of how we're currently operating.
Except the saving provision is if possible, and there may be instances when it's not possible to get the information distributed in advance. But I think aspirationally, if possible, that information should be shared with your fellow councillors as soon as it's practicable.
And I'm out of time, so I'll watch myself here. Councillor Rutherford, go ahead.
Yeah, I think just continuing with that thread, I'm agnostic as to if it stays or not. I just, again, as I mentioned, I can't imagine a scenario in which somebody would file a complaint that would be investigated and lead to any kind of actual violation. And I think Ms. Plouffe's comment is on the nose for me, where it seems so overly broad. Like, so many of us, when we're so for example, I collect a lot of data and my team collects a lot of data. If there's an item that I want to speak to and I want to cite this research and this study on this thing to make my points in my case to my council colleagues. I don't provide that study, maybe from the Edmonton Social Planning Council in advance of me closing to that item. Nor is it actually, it also then tips our hands to where our thoughts are going and leading, right, in terms of that item. So then it also, I don't know. So that's what I'm struggling with and with this clause, because I think if it does remain, it needs to be tighter about when information should be provided in advance to all of council from a counselor, because as it stands right now, I think it is too broad. So I think it's either simplify it or remove it, I guess. What is the harm in removing it? What do we lose in removing it? I'm not really clear on that. Just the decorum piece, because we have lots of other decorum pieces that aren't in a code that we follow.
Yeah, I wouldn't be opposed to removing it, honestly. It seems like a bit of an outlier. It's funny, I've never even really noticed it because it hasn't come up with this council, and I don't think it serves much of a purpose, frankly. But yeah.
Okay.
Yeah, I think there might be, no, I don't disagree with Jamie. I think there might be circumstances, if there's an investigation or if there's some, anyway, I just think there could be circumstances where that makes sense, or if it's pivotal perhaps to a decision that council needs to make, you start to fine tune it of not necessarily the broad base any record, but I don't know, I'm just going to use budget. Of course, you all have budget, but if there's a budget piece that someone's referring to and no one else has it, but you're making decisions on budget, of course you should all have that. But really, that's just maybe a silly example, but I think there are circumstances where that does make sense, and whether that's found somewhere else in the code, that's really what I'm getting at. It's way too broad, but there are circumstances where that does make sense.
Yeah, and I agree. I don't disagree that there's circumstances I don't like the term ambush. I think it's a bit premeditated in a way, and I don't know if that's always the case, but I guess what I'm struggling with is then what is that line? Because we are all of us on council come into a council meeting privy to different information than each other. Whether it's conversations we've had with community members, conversations we've had with administration, research that we've done on our own, preparing for the meeting. And that's what I'm struggling with, of like, every single one of us is privy to different information that we're all bringing to that decision-making table.
Well, I think the clause as it's written would only apply to information, data, or documents that you refer to in that meeting. And I do see value in sharing those, and I appreciate you come to these meetings armed with different data and different evidence. But if you're going to rely on one report to make a point or to move a motion or to try to defeat a motion, as a fellow councillor, if I were a fellow councillor, I think I would want access to that report.
I think this has got to be practical, and I think maybe where the practicality comes in is, and how you might want to deal with this on the ground. Again, I think the chair should be navigating this piece. So if a council refers to a particular document or study or something like that, it could be just open to other councillors to say, can I have a copy of that? And then it really is up to the chair. Do you want to defer a particular discussion until council have had a chance to read it? I'm just trying to find the practical solution.
Yeah.
So maybe again, that's not necessarily something in the code, but something that the chair can manage during a meeting. I'm just trying to find a solution here.
Yeah,
May
I
I say
appreciate.
that's the position I've taken. So when people bring things like, oh, this happened at a meeting, can you investigate it? I don't. And I actually went and got legal advice on this to make sure I was not obliged to investigate that. So I really would like to see it more. I see this as the governance piece, the procedural stuff that I'm not sure it fits within what I would be investigating. That doesn't mean there couldn't be certain conduct that came up at meetings that I wouldn't investigate. But this one seems to me so procedural and good governance versus integrity commissioner stuff.
So maybe, an opportunity here is to delete it and then allow these kinds of challenges or complaints to be dealt with in the decorum rules. So Part C, Section 1. So it's by referencing fairness in decision making. And maybe maybe Jamie can weigh in on that.
Yeah, and maybe just process-wise for us right now, I mean, I'm seeing sort of a few pathways, either sort of a narrowing or fine-tuning as it stands right now, a deletion, and then sort of addition in the decorum section. Is that something that you folks can take away?
I think we can take it away. I think what we want to look at is we do reference decorum, and I think this is a decorum issue. It can be dealt with, as Michelle mentioned, there's some pieces about fairness in decision-making. We can take it away, note it, and then when we bring it back, we can say we think this covers it elsewhere.
Okay, that's I think that's likely a good path forward then. I'll go to Councillor Wright.
Yeah, I was just wondering, Jamie, you'd said not with this council, but I'm wondering for future councils, with the introduction of parties that might have resources or additional resources that are providing that would be providing those councillors with documentation that maybe others not aligned with that party would have.
Understood, Councillor Wright. And so I'm just referring to Part D, Paragraph 1, where we've actually deliberately taken out councillors will comply with the procedural rules for meetings established by council. And this gets back to what I was saying. I think you need to abide by those procedural rules. It's just the chair and those, that I've not been taking carriage over. So, and I do work in other jurisdictions, and I've only ever seen this really come up once, but it was less about the fact that somebody walked in with some smoking gun document and more about their conduct, right? So, and it was really just, it was untowards potentially that way versus, oh, I've got a smoking gun document and I didn't share with you on purpose. I don't know if that's what this is trying to address, but I want to be careful that I'm not being asked to investigate things that this council thinks I shouldn't really be getting my nose in. And this seems to get into that area, and I'm not sure parties will make any difference on that either, honestly.
And it would limit council's ability to gain information or different perspectives, I guess.
Right, so I'm not enforcing your procedural bylaw, for instance.
Okay, thank you, that's all I had.
Councillors, I do have a potential halfway suggestion. It's Cam Ashmore from Legal Services here for those councillors online. You could modify this, and I think this would make it more fitting in a code of conduct context, that a councillor that does produce information will not refuse to produce it to other councillors if requested. In other words, don't hide information. It's not that you need to distribute it beforehand, but if you refer to it and it's not otherwise available to all of council, you need to produce it. That puts a little bit of an emphasis on the chair, but then it would be the refusal to produce it that would become the code of conduct.
I think that seems like a very workable middle ground that makes sense to me. I'm just gonna again look around the table. I know Councillor Rutherford had initially brought this forward as a bit of a flag. So does that seem like a good path?
Sorry, are you asking me?
Yeah, I'll just break procedure myself and ask Councillor Rutherford.
I think that's a great,
Awesome.
clear, and it shows the code action is the refusal. I think it's more clear from a code of conduct perspective.
Okay, excellent. So do you need formal direction to make that change?
We will, but can we do that at the end? We're capturing it as, capturing the thoughts as we go, and then we'll do it at the end.
Perfect. Okay. Well, thank you so much for this discussion. I'm not seeing anyone else on the board for this. So does that mean we get to jump up to 3.1? Oh, yes, go ahead.
So we haven't spoken about, like Brent and I haven't given feedback on these amendments, and I'm wondering if we would have an opportunity just to make a few comments about some of the proposed amendments.
Oh, absolutely. Is that something you'd like to do?
Just very quickly
Yeah,
right now.
for sure,
That's-
please.
That's okay, and just appreciating that, yeah. And the one that I wanted to draw attention to, or just maybe ask Nancy about, is, so in Part D, paragraph 2, it says councillors will comply with council-approved policies. We removed all applicable laws. And then when we flip to Part N, and forgive me, Nancy, we haven't had a chance to talk about this before this committee meeting. Paragraph 2, it says any conduct of a councillor's employee that may be the subject of a complaint or investigation in the code is deemed to be, paragraph 1, in their capacity as supervisors, etc., councillors will fulfill all legislative requirements and comply with the city's policies. So I'm just wondering if there might be a contradiction there, possibly. I'm not sure. And because I'm going to have to interpret this, I might just ask for Nancy's guidance on that.
I would say there isn't a contradiction because this Part N is very specifically limited to capacity as supervisors and so relation to hiring practices, et cetera, whereas the all applicable laws, as discussed probably back in 2023 when we first looked at that, is just a bit too broad for the code.
All right, and so just so councillor knows, or the council knows, I don't investigate breaches of law, but the way the code existed before these changes is if there was a breach of the law and somebody brought it to council saying this person's been found to have violated a law, somebody could make a complaint that they've also violated the code. By removing this, that's been removed deliberately, which is, I just want to point that out. But then in Part N, paragraph 2 is any conduct of a councillor's employee that may be subject of a complaint or investigation under the code is deemed to be the conduct of the councillor. Just want to draw attention because that's a significant change from the previous, unless it's determined that the councillor's employee acted contrary to the councillor's instructions. One of the things I was wondering is, rather than saying the councillor's employee acted contrary to the councillor's instructions, I was wondering if it would make sense to say if it is determined that they acted at the direction of council, which would be a little less of a gotcha. Do you know what I mean? Like in the sense of, it's saying, did my staff member do something that was the opposite of how I've told them to do stuff, versus did the staff member do something on my behest, which is actually outside the code?
I can put that in my list for revisions. The wording was straight out of what was approved in the attachment that came out of the code of conduct, but we can flip it. No
Sorry,
problem.
Nancy.
No
Sorry.
problem.
Yeah, no. I think we might bear lightening up a bit. But yeah, my apologies for the lateness of that feedback.
Does it?
The committee agrees.
Yeah, okay, and just so I'm clear, so it would be switching from acted contrary to, sorry, say that again.
So right now it says you can be responsible for your staff's actions unless they're acting contrary to what you've told them to do. I'm wondering if it should be more that you can be found offside the code if you've told them to do something contrary to the code. Do you know what I mean? So sometimes staff make mistakes, like you have a protocol and they make a mistake and it's contrary to your protocol, but you haven't directed them to do that. This would make you offside the code if they make a mistake versus you saying, I want you to do something on my behest, because if you do it, I won't be offside the code because I can't right now investigate your staff members. So it's just a bit of nuance that I'm sorry I didn't pick up on before, but I think it's an important nuance because I don't want you to be having just a staff member accidentally breach the code versus some counselor, I've never seen it be done, well, I can't do this, but you can do it for me, and then that's okay. So I think that's good.
Okay, that makes a lot of sense to me.
So the language would be if it's determined they acted at the direction of a counselor, as opposed to just contrary to your protocols. Does that?
I think that's a helpful change and provides some additional clarity. So I'm seeing Ms. Jacobson writing away.
Yes.
So you have that captured?
Yes, I do.
Excellent. So any other feedback from Integrity Commissioner or Ethics Advisor?
None from me, Madam Chair.
Okay. We'll really appreciate your input on those. And at this time, we've got that feedback captured. We're compiling it into sort of a singular attachment, correct? And then we'll vote on that in a little bit. But now we can go to 3.1.
Yes, we can.
Okay. Any opening remarks for 3.1 from administration, and maybe I'll go to Ethics Advisor and Integrity Commissioner to see if they have opening remarks as well. No.
It's an important topic with respect to procedures and sanctions, so I look forward to providing input and answering any questions the councillors might have.
Okay, and I know Councillor Rutherford selected this, so we'll go to Councillor Rutherford to start.
Yes, thank you. So I have a potential motion drafted. I think the piece that tripped us up when it came to council, to the council meeting for readings, and in reviewing it, it still trips me up, is the sanction hearing procedures component. Because the way I read it is basically it's two paths. We either go in public and everything is public, or we go in private and everything except for what we decide on a final sanction is in private, as it's written. Is my understanding correct?
Yes, that is the way right now. You make first the decision of whether or not public or private, and then it proceeds down that path.
Yeah. And I think that's concerning to me. I think that there could just be a little bit more clarity around in what instances those would, that private would be needed, and it's a high threshold so that it's clear to the public and to whatever council of the time that the default is public with these extenuating circumstances and conditions. And I also wonder if there should be a hybrid. So I actually have a motion drafted, and I'm just wondering when is the appropriate time to put that motion on, or do we want to discuss first?
I think you can put that on now, Councillor Rutherford. It'll help frame the discussion.
Okay, so I would like to read in my motion. So my motion reads that the attachment 1 of the November 1st, 2024 Office of the City Clerk Report OCC 02479 be referred back to administration to include the following amendments to Schedule C of the Council Code of Conduct. Under Sanction Hearing Procedures, Part A, an option for the Integrity Commissioner's report to be referred back to the City Clerk and Integrity Commissioner to prepare a redacted version that would allow for a public sanction hearing process. Under sanction hearing procedures Part B, clarified that council may move into private if required and permitted under the Freedom of Information and Protection of Privacy Act. And under sanction hearing procedure C, Part C, clarify that a sanction hearing will only be held in private in exceptional circumstances to protect the privacy of a complainant or witness.
Okay, thank you, Councillor Rutherford. Would you like to take a moment to introduce this?
Yeah, as I mentioned, the thing that I think for me tripped me up, I think a lot of the other changes made sense, but you know, we definitely know that this is a very big accountability when somebody's found to have been in violation of the code. There's a public accountability mechanism, and I worry about right now as it's written how there will be perceived potential distrust in that process. So this, I think, provides that clear ability for the council to stand very, very clear in why they're in private, and it's for that protection of the complainant or the witness, and not in any way to protect or bury any of the code breaches of a specific counselor or counselors. I think this just adds that clarity, makes me more comfortable with it, for sure. If any other counselors have feedback, happy to hear it. But that to me just allows for basically we can be all in private if it protects the witness or the complainant. We can have a portion be in private. So for example, if we want to hear from the complainant, we could have that complainant present to us in private, but only for that portion we go in private. And it allows us to determine when a report's provided to us, if there's potential for redaction without compromising identity. So was the intention behind this motion.
Thank you. So we have a motion on the floor. Any questions? So Councillor Cartmel, go ahead.
Thank you. I appreciate the spirit of the motion and trying to put, some guardrails around this. I guess my question would be to the Integrity Commissioner. So I'm wondering about situations where people are making complaints with where it may not be immediately apparent that the complaint is without merit. So I'm going to try, I'm fumbling a little bit. I'm going to try to describe an example for you. Recently, I had somebody that is a theoretically reputed member of the online media that comments frequently on council matters, but deliberately and falsely attributed a comment to me online. If someone turned around and made a complaint about me based on that inaccurate comment, and that becomes part of the public report before it's actually adjudicated by council, it's hard to get ahead of that. It's a little bit of trial by social media before you have an opportunity to defend yourself. That might not be the best example, but I am concerned with, to some degree, about that kind of a thing, about where a complaint is being made that seems substantive in the moment, but when all the details come out, and it isn't. But some of the details are public.
Thank you, Councillor Cartmel. So, yeah, I'm thinking about your scenario, and that's why there is the investigation process where the councillor gets the full opportunity to respond to that, and then it only comes to council if there appears to be a breach. But you should have, as a councillor, been given a full opportunity to answer all of that before it comes to council. I'm trying to imagine there would be new information that you'd want to bring to council other than maybe submissions on whether you think it was fair to have been found in a breach. So I'm Maybe I'm just missing the nuance of what you've described.
Well, I'm not sure. I just have maybe I'm not articulating very well, or maybe my example is not the best, but when I was, working with the investigative and the discipline committees at APEGA, there were questions around conduct that, if they made it to the public domain, could compromise somebody's ability to make a living, could compromise their standing in the community. That, and in that context was in the very narrow view of, well, is their work as a professional engineer or geoscientist really at fault here, or is their character at fault? And there's a difference depending upon what it is you're adjudicating, right? Maybe not so much in this realm, but I'm not necessarily suggesting that everything should be private and then discussed and then become public, but I guess I just wonder about the criteria employed about, who's making those determinations.
Well, and I think the distinction here and the true municipal lawyers in the room can correct me if I'm wrong, is in Edmonton, this council under a bylaw has delegated that function to me. When I do it in other jurisdictions, it's not delegated to me. So because that function is delegated, then when it comes to you folks, it's just a sanction hearing. And that's the distinction between probably a PEGA as well, right? So by that point, it's way down the road, Councillor Cartmel, and it's just the structure in Edmonton, right? So it's a bit different, yeah.
Yeah, and it's regulatory versus bylaw and such. So yeah. Okay, thank you.
And it is a delegated authority, right? So,
Yeah. Okay, thank you very much.
Thank you, Councillor Cartmel. Maybe I'll just take a quick round here, just to maybe provide some. I'll ask some questions that maybe can provide some clarity. So we were kind of getting there at the end, but using Councillor Cartmel's example, this is what we're looking at here in the motion that's put forward, is assuming that we've actually gotten to the point of a sanction hearing. Like there is a lengthy process that would happen before that. If something is found to be, as Councillor Cartmel described, incorrectly attributed, that would be captured in the investigation, and it's potentially likely that it wouldn't actually make its way to a sanction hearing if something is not an actual violation of the code, correct?
I would hope so, yeah.
Yeah.
Yep.
Okay, so that, I think that clarifies it for me. Hopefully that's helpful. And then does administration or integrity commissioner, ethics advisor have any additional commentary on this motion that's been put forward?
Yeah, I just wanted to go back to Councillor Rutherford's comments, if I could, and I agree, and I've said this before. I admire this council for its commitment to the transparency around this process. There's a tension right now in codes of conduct between OH&S legislation, for instance, the FOIP exceptions where you can go in private, and codes of conduct, and where it really becomes a problem. And I like the idea of redaction, but I have other cases in Canada right now that I'm doing where this is a problem because the employer has an obligation to protect certain things that are private, and there's certain relationships that are private that don't belong in the public sphere, but they're covered by the code. Excuse me. So I agree with Councillor Rutherford's comments about maybe we need to be more specific about what those might be, because we do want to err on the side of transparency to provide the proper protections around things like staff complaints and that kind of thing. So there is this tension, and sometimes even redaction doesn't work. So imagine if you had the city manager that it would making a complaint against a councillor, you would not be able to redact it to any effect because you wouldn't be able to figure out what's going on. It would be so blacklined because it'd be obvious. Do you know what I mean? So we have put this back on the Government of Alberta's desk as well in this latest bit of feedback and said, can you guys get OH&S, FOIP, and all of this lined up with the legislation so we can figure out how the process around some of these more sensitive topics, because it's a province-wide problem, a countrywide problem in my view anyway.
Madam Chair, can me and my team weigh in? So
Yes.
I think Councillor Cartmell's example is a good one. And I think, so going to the scope of number 3, there are circumstances that I think we would keep, or we would want to keep report or information in a report private beyond the protection or privacy of the complainant or witness. So, you know, I think 3 is I think we need to work on that one. I do think, you know, I do understand the desire for greater transparency, but I will caution this committee that if we, you know, if you decide to submit a redacted report in public, depending upon the circumstances or how the report is drafted, sometimes it needs to be very heavily redacted in order, because it's circumstantial, you know, like not, you know, sometimes the description can identify a witness or circumstances can't be identified. So then you get the question of trust. And so public, if they look at a report and see it's very heavily redacted, that doesn't help either on the transparency element. So I think that it gets clunky, and I worry about circumstances where there's not enough redaction or too much, and whether that's the direction you want to go. So if I may, I might go to Cam Ashmore. I think he's got some comments as well.
Yeah, and on the redaction piece, I agree with Ms. Plouffe on that 100%. You end up with a little bit of a clunky issue at that point. And I'm going to take that point into having a hybrid hearing where it's partially in private and partially in public. You end up having almost the same problem there, because when you're in public, you would end up having to limit yourself in such a way that you couldn't discuss anything that was in private. And you would have a public motion for the sanction where you wouldn't be able to discuss anything that came out in private as part of speaking to the motion, for example. It creates a little bit of a problem. So it's likely better to have kind of an either or side of things to how to run the hearing. On point number 3 from Councillor Rutherford's motion, the exceptional circumstances, I think that's possible to write that in such a way that we provide a number of types of exceptional circumstances where a hearing might go into private, but leave it a little bit open. So it's kind of provide examples, including X, Y, Z, to maintain privacy of a complainant, to maintain business interests, whatever they would be, but not have an exclusionary list. So that way there's always a way, if needed, to take something into private without closing it off.
Thank you. Councillor Knack?
Thank you, Councillor Salvador. So, I hear the caution piece. I guess I want to explore a few things. So in that scenario, Mr. Ashmore, that you just described, of where, like, you know, council's debating, there was so much discussed in private that it would be hard to have public. I guess the way I read this motion is that, I mean, I would assume the council of the day would just make a decision then to stay in private in that particular circumstance. Like, the way I read the intent of this is that we're trying to send a signal that this is going to be public unless there are truly extenuating circumstances. And to date, I don't believe we've had extenuating circumstances. I mean, we've sat through a few of these, and there have been a number of complaints, but I'm worried the caution is sort of overreacting to something that hasn't happened and is unlikely to happen. And this is really just trying to say, we're going to continue to try to do this publicly, but if there's some extenuating circumstance, we're going to go private. So I guess I'm just trying to, I want to unpack your example to figure out, like, why wouldn't council of the day just then maintain in that example the privacy of that?
Well, sorry, Councillor, what it ends up doing is it puts council under a hybrid approach where they will have to essentially make a decision to remain in private, and they will then at that point be going, well, what consideration should we factor in? How much should be in public? How much should be in private? It's far simpler to have it cut off in a simple fashion, that the moment you have an interest of, for example, a complainant, that everything will happen in private, so that way you don't have to have those public discussions about where are we going to cut things off about what we can keep in private or keep in public. It becomes a little bit more awkward if you have the hybrid. I'm not saying it's not possible. It probably is possible, but it's going to become an awkward procedural issue. So keeping it simple where it's an either or because of an exceptional circumstance is probably the better route to go that is less likely to be challenged in a courtroom.
Okay. Ms. Patel, you had
Just for council's interest's sake, I know this council is extraordinarily transparent. In other jurisdictions, and there's a report coming out in another jurisdiction that I wrote, where they do it in private, and then they come in public, they vote, and they release my redacted report. And so all of your deliberations and your discussions are done in private. I don't think that's at all appealing to this council, but that's how many councils do it, and they're not tripping over this as much. Cam would probably be able to say whether that's more defensible or not, but it's pretty smooth. And then the report comes out, as does the council's decision around the report, but the deliberations are in private.
Are we, so, because I'm trying to, like, I'm hearing the caution, so I'm just trying to walk through it because I maybe not feeling it the same way you do. Is there an example of something, and I'm not necessarily asking, although I guess all of our violations have been public to date, is there an example of something that should have been private in your opinion that wasn't, that we've already dealt with? Because to me, everything that's been dealt with so far feels like it was very validly dealt with in public.
Yeah, Councillor, I'm probably the best one to answer that since I've been around the entire time.
Yeah, yeah.
No, there's been nothing that you guys have dealt with in public that could not have been dealt with in public.
Okay.
So when we're calling this an exceptional circumstance to go in private, as Councillor Rutherford's motion seems to, I think that is a valid way to look at it. It is likely going to be a good chunk of these are going to remain in public unless there is a really good reason to take it in private. All of the other jurisdictions where the default to private, I think they're defaulting on, well, we don't want to discuss how we're conducting ourselves and sanctioning a councillor in a public setting. And I think this council has had the opposite policy decision on that. And I call that a policy decision for a reason, because I think each council might decide separately on that.
Okay, all right. Maybe I'll have, no, I think I'm going to be out of time. Just to our clerks, if I had to step aside for just about 60 seconds, who's our next person in line that we can deputize from the deputy mayor roster? Is Councillor Principe, is she here? Just want to officially deputize somebody so I can.
I can do it. I'm not going anywhere.
Does that work?
I believe it's Councillor Carmel.
Yeah.
Perfect.
Okay. All right, Councillor Carmel, you're on the committee. Councillor Rutherford, you actually haven't had a round for questions, have you? Councillor Rutherford?
I did kind of ask a little bit of a question before
All right, I'll go to Councillor Wright and then we'll come back to you.
I'll be quick. So going from private to from private to public, on a one-off basis, we could make a motion to take it out of private and bring it into public, right? Like right from the start, if we think that, yes.
It is always your decision to go in and out of public and private.
Okay.
So so this is a really crucial point for my office. And I say that because when I do an investigation, and once my report is ready, I give it to the city clerk and it goes on the agenda. So the city clerk has to make the decision at that point whether it's public or not. So that's a problem if there's a reason it should not be public, back to Councillor Cartmel's point. And this is feedback that's been given now to the government of Alberta, where this is an issue across the country, is these codes of conduct, and I've been charged with investigating matters that are coming up from staff. And if a matter comes up from staff, and in my report is entirely put in the public sphere, I'm concerned about the issue of staff members not making complaints in the future, because this is their workplace, and in any other workplace, they would be able to make a complaint. And because counselors are not employees, so to speak, the complaint goes in this way, and it wouldn't be in this public sphere. So you can see how that has an incredible chilling effect on city employees and staff's ability to bring a complaint under the Code of Conduct if it's going to be in the public sphere, where any other employee in Alberta would not have to face that. And so that's where I think it will discourage complaints and concerns from coming forward, and that's the part that I'm very concerned about.
And so then that I guess would need to be taken into account, and that advice would be given if someone wanted to bring forward a motion to move what.
Well, and the issue is even in the course of an investigation, people may not be willing to participate until they know the answer to that question.
Okay.
That's the problem, practically.
Okay, so we, I guess, need to send a signal that confidentiality of their identification or whatever would always be in private then?
In that scenario, I think it's appropriately in private.
Yeah. Okay.
And I think transparency has to give way to the bigger issue of that particular example of providing a proper and safe place for concerns to be brought forward and not have them in the public sphere, balancing out privacy legislation, all of those other things. And yeah, this was a source of big frustration by a lot of the municipalities right now, not just here.
Councillor, if I could just briefly add to that, you may have a scenario where a complainant comes forward and notwithstanding it looks like it's going to affect their private interest, they would want the sanction hearing in public. Nothing wrong with going in public then if the individual wants it in public. So there could be a whole bunch of different scenarios here that could play out.
Okay, and there's nothing we could put in here just to indicate that anytime it's in relation to staffing, it would be held in private?
So again, I think
unless they ask for it to go public.
yeah, I think you could, and it would fall back on what I just said in terms of creating a list that is not all inclusive. So samples of things that might remain in private, but then you don't close the list off and then you still have some reason to go in public. So I don't think I'd probably write specifically unless somebody wants otherwise, but you could say employees' interests are at stake or something like that as one of the reasons to remain in private for sure.
Okay. And then I just wanted to sort of reference back to Councillor Cartmell's circumstance there. What was I going to say? Ask about it then. Sorry. In the procedures, I think it talks about it being that as the Integrity Commissioner, you can determine that it's frivolous or vexatious, right? So if it was something that was unfounded, that would be frivolous?
So there are many ways that I dismiss complaints. I found that it's not true, as you know, it's frivolous, vexatious, an abuse of the process brought in bad faith, or it just is not meritorious of an investigation, something
so
very trivial. Yeah. So I dismiss way more than I investigate, just so you know. And outside of my jurisdiction, obviously, I wouldn't investigate as well.
Okay, I did have some other questions, but not related to the amendment here.
Okay. Councillor Rutherford.
Yeah, thank you. I'm actually, okay, so I'm really confused as the concern here because we're talking a lot about the privacy piece, and I have, in this motion in front of us, I have not made any proposed amendments to report submission. So it still says that the agenda of the council committee meeting where there will be a sanction hearing will be published 10 clear business days, that the integrity commissioner's report remains in private. And then again, that's still a council decision. So I'm like, at no point does the motion in front of us on the floor request that the city clerk or anybody has to make that determination determination about whether the report is private or public. So I'm really unclear about sort of that line of apprehension.
And sorry, Councillor Rutherford, I didn't pick up on your motion on that aspect of your motion. Yep, that makes sense.
Yeah, so it's just specific. My motion is only specific to the sanction hearing procedures. It doesn't touch on or amend anything related to the section on reporting whatsoever. Does that help assuage some of your concerns?
So Councillor Camp Ashmore here. So my concerns are more about bouncing in and out of private during a hearing. So I have a little bit of concern about having a redacted report that is out there that is so redacted that it effectively should have remained private in the first place.
Well,
But I don't really have concerns about the first part of your motion per se.
Yeah, so I think I need to explain a little bit more my intention and see if that's the understood intention and if there's a clarity around that. So if the report comes, it's published on an agenda, it comes in private, the very first step is always part A. Do we want to have that report public or private? And at that point, we might decide to refer it back for a redacted version because we as a council of the time, whomever that council is, determines that there is ability to redact and that there's still information of public interest that would be gleaned from a public report. That is my intention with the first part. Are there any concerns with that? And so then it would be referred back and it would come back for another sanction. The sanction hearing would come back with a redacted version. So it'd be very clear also to councillors what they could discuss in public and what they could not.
Yeah, I have no concerns with that, Councillor.
Okay, and then under section 2, that the move to be in private, if required, would only be under a FOIP, which I've already heard from this advisory, like from all of the legal advisors, that we already have discretion as a council at any point to do that anyway.
Yes, correct, Councillor. There's no concern about the specific way.
But just clarify.
Yeah,
it's just
my
clarifying.
concern was about bouncing in and out of private and public.
Okay, so then we'll
during
go.
hearings.
So then we'll go to part 3. Part C still basically says that an entire sanction hearing can be held in private under exceptional circumstances. But I wanted to put some guardrails around what those exceptional circumstances were, so it's clear to members of the public that it isn't for, in the case of, for example, a political party wanting to bury code of conduct issues that might hurt the party's overall perception, as an example.
Right, Councillor, and that's where where I've said that we could create such a list of exceptional circumstances, but would not want to close it off. So
Okay. So could we just, so you have no problems really, if based on what I'm understanding, except for section 3, where we maybe limited it too much with the protect the privacy of a complainant or a witness. So it might just be exceptional circumstances, period. Or do we want to outline what those exceptional circumstances are?
Yeah, perhaps, Councillor, if you would modify section 3 to say provide examples of exceptional circumstances, that would allay my concerns.
Okay, well, I can't modify it, but I'd be welcome to that. But I think otherwise that helps clarify for me. Thank you.
Thank you, Councillor Rutherford. So just to, Councillor Knack. Nope, go ahead.
I was just going to say then if Councillor Rutherford can't modify it, then I can see if that's a friendly amendment to modify that.
I would perceive it as friendly.
Sorry, what was that, Councillor Rutherford?
I said I would perceive it as friendly.
Okay, seeing nods. Yeah, okay, so that's friendly. Councillor Knack, did you want to ask additional questions?
No, thank you.
Okay, Councillor Wright?
Ms. Pytel, does that allay your concerns that those complainants or witnesses will still feel protected if it's not specifically specified there?
Oh, that certainly moves the needle very far, and so I'm quite pleased with that. Yep, yep.
Okay.
So, thank you.
Okay, so I'm not seeing any other folks on the board for questions. So again, we have a motion on the floor with, is that friendly amendment reflected in the wording? Not quite. So I'll just pause for a second just to make sure that that's reflected on the board. Okay, is that only be held in private in exceptional circumstances? Is that reflective of the friendly amendment there, Councillor Knack? Just having a period at the end? Maybe I'll just go to Mr. Ashmore. Is that reflective of the change that you suggested?
Well, Mr. Ashmore's thinking.
I'm not sure it meets Councillor Rutherford's original purpose for this. That's my only concern. I think the way I would rephrase it to clarify that a sanction hearing will be only held in private in exceptional circumstances, providing examples of such circumstances, something along that line.
Keep in mind, this is asking us to refer back for very intentional reasons, because we'll have to do some work to split out these processes, so.
Yeah, so, because my initial reading was, yes, there would be language around, provide some examples.
Yes.
Just so that we know what those parameters would be. So can we reflect that in the language? So in exceptional circumstances, comma, providing examples of exceptions.
Absolutely, we would do that
Okay.
anyway, but we can put that word in so it's very clear.
Thank you. All right. Well, while that wording gets cleaned up, I will look to any colleagues if there is anyone who wants to speak to this item before Councillor Rutherford closes. I'm not seeing anyone. Councillor Rutherford, do you want to close on this?
No, nothing further at this time.
Okay, then let's vote.
Just waiting on one vote.
I'm a yes.
Thank you. We have all the votes.
Please display the vote. That is carried. Okay, so that takes care of 3.1, but we do have a document that's being compiled with some of the changes and suggestions for 3.2. Is that ready?
Clerk, can you put up the draft wording? So this would reflect what we heard from the substantive code of conduct, the 3 changes when it appears on the screen. If that works, that will just give us direction to make these amendments. And while they're doing that all procedurally, if you'd like, what we could do is these ones, because they are fairly straightforward, could be done and sent up to council services. The one you just passed will need a bit more time, so it will come back to a different council services committee.
Okay, thank you for that. And next Council Services Committee is not too far away.
It's Wednesday, which is why
Yeah.
we can only do the second part,
I was
yes.
going to say, I appreciate the timeliness of bringing some of those simpler ones forward, but looking forward to the larger ones in the future. Okay, so I'm seeing the wording up on the screen here, so I'll move this. I'll move that attachment 1 of the November 1st, 2024 Office of the City Clerk Report, OCC 02272, be referred back to administration to include the following amendments to Schedule A of the Council Code of Conduct. 1, Part K5, that city funded before website and electronic mail distribution lists 2, revise Part C3 to clarify that councillors that provide information in a meeting that has not been provided to all of council in advance must not refuse to provide a copy to all members of council. And 3, revise Part N2 to state that it applies only if the employee acted at the direction of the councillor. Okay. So have a motion on the floor. Doesn't really need an introduction. This is reflective of the conversation that we had today. Really appreciate administration capturing all of this. So anyone to speak to this or questions? Councillor Rutherford, do you have questions?
Yeah, I just realized Councillor Jantz wasn't able to make it, and he had a couple questions that I don't think we ever covered. Am I able to ask a question on his behalf?
Oh, sure, yes, please go ahead.
Okay, just looking for his message to me. I think he was concerned about the confidentiality piece and like dismissing the complaint if section, specifically wondering why this change is being made.
Councillor Rutherford, are you talking about Schedule B, the investigation process that allows the Integrity Commissioner to potentially then use
Yes.
that behavior? So
Yeah.
this was something, I'll let the Integrity Commissioner get caught up in comment, but this is something that was asked for during the conversations.
Yeah.
Sorry, I'm just trying to catch up. Which section are we referring to?
You're in
She
Schedule B.
doesn't say. Says Schedule B.
Yeah, under
Pardon?
investigation.
That's right here. So, but I'm not seeing any red lines. Sorry, Nancy, do you know what amendment?
So I think I'm gonna read. I'm gonna just take my discretion to read as from his messaging, so it's directly from Councillor Jantz's words. If someone makes a complaint and chooses to publicize it, the Integrity Commissioner may throw the complaint out, but may not. And this is all they can do to penalize the complainant. The complainant may lodge a complaint just to make news, lodge a complaint that then sends to media, post on socials just to make an issue or embarrass the councillor. And the councillor wouldn't be able to say anything because of the proposed change. And that's what his concern is. I'm just relaying.
Nancy, can you just clarify what was redacted in that, or what was changed? Because I can't seem to see it on my version.
It's entirely a new section in there. So that part at the top of the page there is entirely new.
Okay, here. Just give me one moment, please.
Sorry, I apologize.
Okay, so I've read, sorry, Councillor Rutherford, could you please repeat Councillor Jantz's concern?
His concern is, I think, that the counselor won't have any ability to defend themselves. So basically, if that's what it says, that the counselor would not be able to say anything because of this proposed change. So the person could fabricate something, so bend the truth, and the counselor couldn't clarify it. I don't know if this is necessarily an issue, but I think he just wanted, that was a concern he had with that change in the part.
Oh, I understand now. So the way the code originally used to read before these amendments is the confidentiality requirement was really only on the respondent counselor. So this has broadened it to give some ability to say to a complainant, who it can be anybody, right? Not just somebody on council. Give me as the Integrity Commissioner an opportunity to say, complainant, respondent, everybody, you must keep this confidential. But if a complainant who is, let's say, a member of the general public goes onto social media and does all of this stuff before my investigation is completed and And I believe Councillor John's concern is that the councillors are stifled because of the code from saying something, whereas the complainant, and I have no ability to contradict that, can publish this and say all kinds of things. Oh, I've made a complaint and the Integrity Commission is looking at it, et cetera, et cetera. So we tried to come up with something that I would at least be able to look at the motivations of a complainant who's doing that. So I ask everybody to keep it confidential, but I don't have a lot of resources in terms of a member of the public, for instance, breaching confidentiality other than to deal with it in my report or my process, or possibly consider it a vexatious or bad faith complaint. And so there is a problem with that. I have to say, in the past, I've been very careful when, and Brent, I'm sure, has given advice on this, if a complainant has gone public with a complaint, and we did have that situation, and it was quite broadly published, the councillor, the complainant has now waived the confidentiality of them, you know, in terms of them being a complainant. The problem is it's a whole process we're trying to protect, but the councillor in limited circumstances in the past have acknowledged something because it's now been put in the public sphere. So, but I really guard against it because it can look like they're retaliating against somebody for bringing it forward. So it's not ideal. So we've tried to put more information into the code to address the fact that it's imbalanced in terms of the confidentiality requirements. And I do take into account if a complainant has gone public with the complaint moments after sending it to me, because that's almost all I can do. So it's a bit better than it was before, but it's still not ideal.
So not perfect, but better.
Yeah.
Okay.
Thanks, Councillor Rutherford. So just to build on that, the addition is really to actually discourage the behavior that Councillor Jans is concerned about, recognizing it's always been a problem. This is just sort of to reduce those instances if possible. Is that a fair understanding?
Correct, yeah. And to give me, explicitly give me the opportunity to take that into account, right? So I don't want to be punishing complainants for bringing complaints, but if this is being used to abuse the process or really just, you know, for other reasons, and the councillors in this unequal ability to respond to it, I see the unfairness in that completely.
Yeah. Councillor Wright?
I thank you. On that same document, since we're there, I think page 16, I think it is, just the process. It says at the top of the page that you may provide a copy to the complainant. And then later in the process, it says that no later than 12 clear days, the complainant has the opportunity to write a written response. How can they write a written response if you've decided that they may not get it? And then the other point is, again, timeline, posting to the city's website 10 clear days, but yet they have to respond 12 days, like 2 days prior to that.
So to start to reverse order, the 2 days prior to that is to allow us to meet that publication deadline of the 10 days. If they weren't given a copy, then there's nothing for them to respond to, and that section just wouldn't apply.
Okay, but if they were given a copy, so I guess, to Jamie, what would determine whether or not you would provide them a copy or not?
So often code of conduct complaints are not personal to the complainant, they're just pointing out a breach of the code, right? So, and then my position in the public interest is to enforce the code, and it's not, you know, personal to that person, right? So they're bringing it, and our process up to this point, which I think would be the same or very similar, is they get it when council gets it, right? And when it becomes public, because it's really not personal to them. Does that make sense? There may be situations, though, where the complainant would anticipate wanting to come to council and make representations, so they would get the complaint the report in advance.
Okay, so I'm rereading this now, and it would be the complainant, if applicable, that is, okay, read it too quickly. Okay, I think that helps to clarify it. But nothing to, we don't need to define when it would be applicable. It was just, okay, thank you, that's all I had.
Thank you, Councillor Wright. So any further questions? If not, folks can also sign up to speak if they're interested. So not seeing anyone else on the board, I'll just take a moment to close to this. Yeah. So yeah, just wanted to take a moment to, again, express my gratitude to, of course, Administration, Integrity Commissioner, Ethics Advisor for, I feel like we've been on a journey with this, but all the work that you've done to date and the work that is ongoing to ensure that we are, holding ourselves to a really high standard and that we have the correct processes and procedures and bylaws in place to make that a reality. So really appreciate the conversation today. Looking forward to this coming to Council Services Committee. And thank you to colleagues for their ongoing participation. And we can vote. I'm a yes.
Thank you. We have all the votes.
Display the vote. That is carried. Okay. So I don't think there's anything else that we need to do on the agenda today, but
So Councillor Salvador, if we
yes.
could actually make one more motion to, and I'll pop it in the chat, to refer the revisions back to administration.
Absolutely. I'll watch for that wording. Okay, I'll move that administration bring forward a revised attachment 1. Oh, it disappeared.
It's coming back.
Okay, so I'll move that administration bring forward a revised attachment 1 of the November 1st, 2024 Office of the City Clerk Report, OCC 02272, to a future Council Services Committee meeting. Any questions or thoughts on this one? Seeing none, please vote. I'm a yes.
Thank you. We have all the votes.
Please display the vote. That is carried.
Councillor Salvador, last piece, because you haven't given us direction yet either way, is private attachment 3.
Oh, yes. Okay, and you'd need direction whether or not that actually stays in private, correct?
Yes, as we suggested in the report, it's something you consider. The timing might be best of when the code of conduct is finalized, because this summarizes conversations in private, but if you do want to keep it in private, we just need that motion today.
Sure, yeah, and sorry, just to clarify what you just said, so if we keep it in private today, there is the option to bring that forward when we close out all of this work?
Absolutely. Perhaps
Yeah.
when council considers the final bylaws, you
Perfect.
could release it then.
Yeah, okay, because I am interested in making that public as well, but for today's purposes, I'll move that it remains private pursuant to sections
23 and 24.
23 and 24. Okay, any questions or concerns with that remaining in private for the time being? Seeing none, please vote. I'm a yes.
We have all the votes.
Display the vote. That is carried. Okay. So I think now we've
And Councillor Salvador, one more.
One more,
Thank you.
okay.
This one is for administration to bring forward a revised attachment 1 of the November 1, 2024 Office of the City Clerk Report, OCC 02479, to a future Council Services Committee meeting. And it will be showing up on your screen shortly.
Thank you. All right, I'll move that administration bring forward a revised attachment 1 of the November 1st, 2024 Office of the City Clerk Report, OCC 02479, to a future Council Services Committee meeting. All right, questions, comments, none? Let's vote. I'm a yes.
Thank you.
Yes.
Thank you, Councillor Rutherford. We have all the votes.
Please display the votes. And that's carried. We're good? Okay, so private report's done, which means we are